California Lemon Law Introduction. The California Lemon Law is designed to protect consumers who happen to have purchased or leased a vehicle that ends up being defective. While the California Lemon Law has a presumption clause which states that if you have the same serious defect repeating 4 or more times, the vehicle is presumed to be defective. Case law, which means cases that have been litigated and won in court, have established that in certain instances, if you have the problem repeating twice, if that problem is life-threatening, it's such a serious problem that causes a serious threat to the driver or the passenger's life, then it may be sufficient that after 2 repair attempts for a vehicle to be deemed defective, for it to be considered a lemon, and for the manufacturer to be obligated to repurchase that car and give a refund to the owner of the vehicle. The individual who owns the car is entitled to a refund of his or her down payment and monthly payments. The consumer is also entitled to a refund of consequential damages such as towing or rental expenses that are incurred while the vehicle is at the shop being repaired. However, it does allow for the manufacturer to deduct a mileage offset for use of the vehicle up until the point the vehicle is deemed to be defective. Typically, the formula that's used is the mileage at the first instance of the repair multiplied by the purchase price of the vehicle divided by 120,000 miles. The idea is that the lifespan of a vehicle is 120,000 miles. Let's say if you had the car and you drove it perfectly fine for the first 12,000 miles. 12,000 miles is 10% of 120,000 miles. Therefore, the manufacturer gets to charge you 10% of the purchase price. So whatever price you agreed to pay on day one when you purchased the vehicle, that is the number that's used. So, for example, on a $50,000 car, 12,000 miles of use without any problems would result in a $5,000 offset, 10% of the $50,000 purchase price. We are often asked whether we can lemon used vehicles or vehicles that are no longer under the warranty. The answer to that is yes, however, it depends on the circumstances. If you purchased a vehicle which was used, however, had some of its original manufacturer's warranty available, and you experienced problems during that original manufacturer's warranty period, then you are still able to utilize the California Lemon Law. And then part 2 is whether if we're able to litigate or succeed on a case where the warranty has expired. The answer to that depends on whether the vehicle had defects prior to the expiration of the warranty. If you purchase a vehicle and during your ownership you have experienced several problems which occurred during its warranty period, the warranty expires and then you experience the same defect, we are oftentimes able to argue that had the manufacturer properly repaired the vehicle during the warranty period, you would not have had to endure the same problem after the warranty expired. Therefore, the defect is still the manufacturer's obligation, and therefore the Lemon Law still applies and our clients are able to get a refund.